Hey there, everybody, and welcome to Law and Crime Now. I'm Jesse Weber, and thanks for joining us. First up, there is so much to get into in the continuing saga of Lori Vallow Daybell and her husband, Chad Daybell. The couple have been hit with new charges that they, along with Lori's brother, Alex Cox, conspired to remove the remains of Lori's children, Joshua J.J. Vallow and Tylee Ryan. As you recall, the bodies of these children were found on Chad Daybell's property. Now, this all comes after police executed a third search warrant on his property, although the details of what they found are still unknown. I'm going to turn right now to a portion of Chad's hearing on these new charges from earlier today, where you're going to hear what overt acts he allegedly engaged in furtherance of this conspiracy. Take a look.
About November 26, 2019, Chad Guy Daybell misrepresented the nature of his relationship with Lori Vallow while questioned by the Rexburg Police Department during a lawful investigation regarding the whereabouts of J.J. Vallow. On or about November 26, 2019, Chad Guy Daybell contacted Melanie Gibb via phone for the purpose of requesting and or encouraging non-cooperation with law enforcement's lawful investigation regarding the whereabouts of J.J. Vallow. Number 3, on or about November 26, 2019, Lori Vallow provided a false and or misleading physical location of J.J. Vallow to law enforcement during a lawful investigation. Number 4, on or about November 26, 2019, Lori Vallow contacted Melanie Gibb via phone for the purpose of requesting and or encouraging non-cooperation with law enforcement's lawful investigation regarding the whereabouts of J.J. Vallow. Number 5, on or about November 26, 2019, Lori Vallow contacted Melanie Gibb via phone for the purpose of requesting and or encouraging Melanie Gibb to prepare and or present false evidence to law enforcement regarding the whereabouts of J.J. Vallow during a lawful investigation. Number 6, on or between the dates of February 30th, 2020 and June 9th, 2020, Lori Vallow refused and or did fail to comply with a court order to produce her minor child, to wit, J.J. Vallow, to the Rexburg Police Department or the Idaho Department of Health and Welfare in Madison County case number CV 3320-45. Count number 3, destruction, alteration, or concealment of evidence, which is a felony under Idaho law, violation of Idaho Code 18-2603. It's punishable by up to 5 years in the state penitentiary and up to a $10,000 fine. It alleges that the defendant, Chad Guy Daybell, on or between the 9th day of September 2019 and the 9th day of June 2020, in the county of Fremont, state of Idaho, did willfully destroy, alter, and or conceal, and or did aid and abet another to willfully destroy, alter, and or conceal the human remains of Tylee Ryan.
All right, joining me now is Law and Crime's own Terri Austin, as well as psychologist Dr. John Delatorre. It's great to have you both here. Terri, want to start with you. What do you think led authorities ultimately to hit them with these new charges? Because the facts in this affidavit are very similar to what we knew weeks ago when Chad Daybell was charged. So why didn't they bring those conspiracy charges then against them? Having said that, as I said at the top, the police just executed this third search warrant on his property. We don't know what they found as of yet. What led them to these charges now?
Well, the big difference, Jesse, between these charges and the other charges, obviously, is the fact that it's a conspiracy. And I think the reason they are doing it at this point in time is because the pings on Alex Cox, the brother, his phone put him at the scene of the crime where the bodies were found on the days that we know both JJ and Tylee were missing. And I think that the authorities said to themselves, okay, this is the nexus that we need to connect Lori Vallow and to collect Charles Vallow with Alex. So that's where the conspiracy comes in. I think those pings on the phone let them.
You mean Chad Daybell? Chad Daybell.
Chad, yes, exactly.
Right. And,
So
and
I
Terry,
think
let me ask you about this. Let me ask you this. We have a weird situation because it's our understanding that Chad's daughter, Emma, and her husband have been living in that home, effectively that crime scene, which was right after his arrest. I don't understand. I mean, why should they have been allowed to be in that property? And isn't that very dangerous in terms of evidence preservation? I mean, don't you see that as a real problem?
I see it as a huge problem. Garth, I think, is the son-in-law's name, and Emma have been living there. They've been going in and out, taking things in and out. And it is where we know that the bodies were found, or at least the house is next to where the bodies were found. So allowing them to live there and to disturb the crime scene, in my opinion, is really an abduction of duty. They basically should have made sure they cut off the scene, and no one should have been able to go in and out, much less live there.
Well, look, again, what the authorities found during this third search is going to be interesting. But doctor, I'm glad to have you on here because first I want to ask you the million-dollar question. They haven't been charged with killing these kids as of yet, and I'm going to get into that in a second. But to be charged with what they're charged with, what is the psychological makeup of somebody that would do this? And number two, do you think manipulation plays a role here? Whether it is Chad manipulating Lori, Lori manipulating Chad, Alex being manipulated, vice versa. I mean, we could speculate. Just give us an insight into what we should be thinking about here.
All of this is kind of gathering towards this idea that all of them planned all of what happened. There wasn't any more conspiracy theories. There isn't doomsday preppers. There's none of that. And I think that's what the prosecution is leaning towards, is that all of these people were complicit. They weren't acting through some message from God or anything like that. These people engaged in very destructive, hurtful behavior. These two innocent lives were lost. In terms of manipulation, who's manipulating who? That's hard to tell. Because it does sound like at least Lori has been laying the groundwork for mental disorders and Capgras syndrome and all these other things that are going on, and perhaps even that she's a victim of her ex-husband's issues, right? She seems to be laying groundwork, and so it wouldn't be far-fetched to think that she's sort of a mastermind when it comes to what ended up happening to the two children.
Look, we're all trying to make sense of this because this is a story that really doesn't make a lot of sense. You mentioned Lori. So as I said, Lori was hit with the same charges as Chad, these conspiracy charges. Let's go to her hearing. And the question is she going to get out of jail? Is there a lower bond? Take a listen.
Ms. Daybell, I have set your bond in the arrest warrant that you have there in front of you, and I've set bond at $1 million. Mr. Means, I'm not going to take up that matter here today. If you'd like to file any motion to deal with that in the future, that can be dealt with. Do you wish to be heard on that matter?
Yeah, Your Honor, we can reserve the matter for a later time.
So both she and Chad remain in jail on $1 million bond each. Terry, you know what I'm going to ask here. People are surprised when we thought there would be a new announcement in this case. Chad Daybell, Lori Vallow Daybell charged with murder. They have not been charged with murder. Are we getting to a situation here where authorities may not be able to have the evidence tie to them in the sense that they might not know who killed the children, what caused their deaths at this point, especially if one of the co-conspirators, Alex Cox, Lori's brother, is deceased? Are we getting to that reality where these two may not be charged in connection with the actual killings or deaths of these children?
Jesse, I surely hope that that is not the answer. Based on what we know from all of the reports, the authorities have plenty of information to connect those dots. They don't need to have the smoking gun. They know where the children were right before Alex Cox took them. And they know that the fact of the matter is they were with Lori. And the last time they were seen were, in these pictures, you see them smiling and happy, one on the 9th and one on the 23rd. We have Melanie Gibb, Lori's best friend, connecting some of those dots. So I think there's enough there. It may be circumstantial. And Alex Cox, the one who actually did the murder, might be dead as well. Obviously, he is. But I think they have enough, Jesse.
Well, it's interesting because we've covered cases before where people are charged for murder when there's no body. So the fact that they haven't been charged here is interesting. Doctor, I want to get to your question about this because the relationship between Lori and Chad is something to follow here. We know that yesterday, Lori Vallow said she wanted to be referred to as Mrs. Daybell. Chad had been visiting Lori every day until his arrest. There's a question of, will one turn against the other? Do you think that that's ever going to happen, or are they bound together in this pact, whatever that might be? What do you make of their relationship?
I think it has to do with who's ultimately the dominant personality in this relationship and who's the submissive personality in this relationship. If the dominant one, so let's say that is Lori, if she would end up being the one who decides, well, I'm going to turn on him, and the submissive one, this being Chad, wouldn't do anything. So I think ultimately, if the two of them are in it together and that they're both sort of on equal footing in terms of the power dynamics of the relationship, then no, they probably won't do anything.
Okay, well, we'll see what happens with both of them. I want to talk a little bit more about this. So we're going to take a break. We'll talk more about the Daybells, and also we'll talk about the Golden State Killer big week in terms of putting a close on that saga as well. We'll be right back right after this. Welcome back, everybody. We're still talking about Lori Vallow Daybell and Chad Daybell, the couple who've been hit with new charges that they, along with Lori's brother, conspired to dispose of the remains of Lori's children, the remains that were found on Chad's property. Now, we go back to earlier when Chad was in this hearing with Judge Eddins Faren, where he was hit with these charges. You hear these charges, and listen carefully to more of the overt acts that are alleged he engaged in furtherance of this conspiracy. Take a listen.
Overt acts. In furtherance of the conspiracy to commit destruction, alteration, or concealment of evidence and to affect the objects thereof, one or more of the following overt acts were committed by one or more of the subjects of the conspiracy within Fremont County and or elsewhere. Number one, on or about September 9th, 2019, Chad Guy Daybell sent text messages to another for the purpose of disguising the destruction, alteration, and or concealment of the human remains of Tylee Ryan on his property. Number two, on or about November 26, 2019, Lori Vallow provided false information to law enforcement regarding Tylee Ryan's attendance at BYU, Idaho, and or her current housing situation. Number three, on or between the dates of January 30th, 2020 and June 9th, 2020, Lori Vallow refused and or did fail to comply with the court order to produce her minor child, Tylee Ryan, to the Rexburg Police Department.
Okay, Terry, back to you. Whether it's allegedly lying to police, telling Melanie Gibb to not be forthcoming with police, allegedly sending text messages to cover up the burning on the property, these overt acts to show how they were literally trying to help dispose of the remains so police would not get a hold of them. The question, of course, is, as we enter into preliminary hearings, what kind of defenses do you imagine here? Because this is some really odd behavior, and I can't imagine, I need you to help me out here, with what we might hear by defense attorneys to explain away these acts, this behavior on the part of Lori and Chad.
It's going to be very difficult, Jesse. And I think the reason is because that conspiracy charge is there. So you might hear one of them say, well, it wasn't me, it was Chad. Lori might say it was Chad. Chad might say it was Lori. They both might say it was Alex. So I think the really smart move here is the fact that prosecutors put the conspiracy there, because it doesn't matter with conspiracy, as you know, under the law, if they can show that indeed one of them did it and the other conspired, they can convict both of them of the charges that they have. I am still very confused, though, why they didn't include murder. As you know, in Idaho, they found the bodies. It's not like they have to wait 5 years if they hadn't found the bodies. So I think they should have had conspiracy to commit murder as well.
Well, there's a long time between now and that preliminary hearing. Who knows what will end up happening, and maybe they will face additional charges, maybe not. And if that becomes the case, the question will be why. We'll talk more about the Daybell saga as it continues, but I want to turn my attention to something else, because Joseph James DeAngelo, the purported Golden State Killer, this week he pleaded guilty to 13 counts of murder, 13 counts of kidnapping, and he admitted to uncharged rapes and burglaries. And he did this all a part of a way to get the death penalty off the table. This is a plea deal where the death penalty would be taken off the table, and in exchange, he will be sentenced to multiple life sentences in prison without the possibility of parole. Now, during this hearing, the prosecutors from different counties detailed his crimes, his whole crime spree, and it was awful to hear what he did. But really, what was even more remarkable is to hear him after these horrible descriptions, and he's in a wheelchair, he seems to be very frail, just confirming what he did. So here's a sample of one of his crimes, and then you're going to hear the man himself. Take a listen.
On the evening of September the 4th, 1976, Jane Doe number 1 went to her parents' residence located on Crestview Drive in the city of Carmichael, County of Sacramento. The victim went to her parents' residence to do some laundry. At approximately 11:15 p.m., she loaded the clean clothes into her car that was parked in the street in front of the residence. After placing the laundry inside the car, she turned around and was suddenly confronted by Joseph DeAngelo, who told her, "Don't scream." DeAngelo immediately punched her in the face and broke her nose. After the victim fell to the ground, the defendant dragged her to the side yard of the residence, which was not within view of the street. At this point, DeAngelo forced her face down onto the ground and tied her hands behind her back with some shoelaces that he brought with him. At knife point, DeAngelo led her into the residence while threatening to slit her throat. He said, "All I want is your car so I can get to Bakersfield." Joseph DeAngelo unlawfully kidnapped and carried the victim away with the intent to commit robbery within the meaning of Penal Code Section 209 and used a knife to do so. DeAngelo's decision to move the victim away from the driveway, down the side yard, and ultimately into the house was more than merely incidental, as it substantially increased the risk of harm to her above and beyond the crime of robbery itself. This movement fundamentally changed her environment and greatly minimized the chances of someone seeing the crime or hearing the victim's cries. It increased the possibility of further crimes being committed against her. Once inside the house, DeAngelo held a knife to her throat and placed his penis in her hands, which were still bound behind her back, and forced her to masturbate him. The victim said his penis felt greasy, like he had rubbed lotion on it. DeAngelo then raped and sodomized the victim as she screamed in pain. After forcing the victim to orally copulate him at knife point, DeAngelo continued to sexually assault her multiple times before tying her legs to an electrical piano. While sexually assaulting the victim, he taunted and threatened her by repeatedly saying things like, "You better do it right or I'll kill you. Have you ever done this before? You like to quote unquote fuck with who?" After the sexual assaults, the defendant ransacked the house and drank beer from the refrigerator. DeAngelo drove away from the scene in the victim's car and stole her purse.
Jane Doe 1, having occurred September 4th, 1976, in the County of Sacramento, a violation of Penal Code Section 209. To that charge, sir, how do you plead?
Guilty.
It's also an allegation that you personally used a knife in the course of that robbery in violation of Penal Code Section 12022 of the Penal Code. You admit or deny?
I admit.
I mean, does it get any worse than that? Dr. Delatorre, what is your opinion on the psychological makeup of DeAngelo? And you couple that with the fact that one of the prosecutors alleged that DeAngelo was faking this whole frail act. He actually said he feigned feeble incoherence when he was arrested, because they say that he was lifting heavy objects at the time, and that he was jumping in and out of his truck. He was riding a motorcycle weeks before. So this is a whole act he's putting on here. Your opinion on this?
Yeah, based on the behaviors that he was able to do just in the one description, I think he meets criteria to be diagnosed with a sexual sadism disorder. And this is a paraphilic disorder. And this is someone who requires power and control throughout his life. So I'm not surprised that there's a lot going on. And then when confronted, if he is feigning these symptoms, when confronted, he's once again trying to retake power, but this time in a more passive way by demonstrating that he has no power, that he's not a threat to anyone anymore.
What about the pattern? Or let me rephrase that. What about the progression? Because it started off where he was doing these burglaries, then attacking women on their own, then moving on to couples. That progression, what do we make of that?
Right. So the idea is that he's progressing, that he's moving more. What I would say is that even the burglaries probably had some kind of sexual component to them. At the initial time when he's breaking into places, he's probably stealing things, or he's probably doing other kinds of sexual behaviors that maybe aren't rape. But then over time, his fantasies are so much that he has to now engage in the rape that he's probably been thinking about as he's been doing these early burglaries. So I think they were always pretty intense kinds of things. It was just time for him to then do what he had been fantasizing about.
Frightening. Terri, we have about 30 seconds. Is this justice? Because when you hear what he did, the death penalty was taken off the table, yet he will spend the rest of his life in prison and admits to everything that he did, and he's given closure to families. Having said that, how important was it really to have him sentenced to death?
Well, I think, the fact that he's pleading guilty, the fact that we don't have to spend time, effort, and money in making sure that he is found guilty, I think it was very important. And I do think this was the right way to go. And, sparing his life, well, I don't think that is as important to the families. I think it's more important to make sure they have at least some closure.
Well, speaking of the victims and the victims' family members, we're going to hear them August 17th at a sentencing hearing where victim impact statements will be permitted. When we come back, though, we're going to focus on updates in the Rayshard Brooks and George Floyd cases. We'll be back. And welcome back. Onto the shooting of Rayshard Brooks out of Atlanta. The former officer who has been charged with killing Brooks, we're talking about Garrett Rolfe, he has been released from jail on a $500,000 bond. The judge ruled that Rolfe does not pose as a flight risk or a danger to the community. And I got to tell you, it was an interesting hearing when you heard the back and forth between the prosecution and the defense. Almost felt like a mini trial here. And I want to start right now with Rolfe's attorney giving a background of Rolfe as a justification for a low bond. Take a look.
Officer Rolfe's professional career as an Atlanta police officer. Officer Rolfe is a 7-year veteran of the Atlanta Police Department. He's been a police officer. He was hired on with APD when he was 20 years of age. One of the letters that the court has before it describes Officer Rolfe as being the youngest person in his class. He was the valedictorian of that class when they graduated. In addition to being a certified police officer, Officer Rolfe is one of 200 drug recognition experts in the state of Georgia. Again, one of the letters that is before the court describes the process by which it takes to become a drug recognition expert. The person who has talked about this in his letter describes it as it's akin to a semester in college with a high failure rate. Officer Rolfe was the valedictorian of his drug recognition expert class. During his career, his 7-year career, he's received several commendations for his work as an Atlanta police officer. Notably, in addition to working full-time as an officer, a police officer with APD, Garrett Rolfe is also pursuing an undergraduate degree at Kennesaw State University, where he majors in criminal justice and psychology. He's currently, because of the situation that he finds himself in, he's currently withdrawn from classes, but at least until this incident happened, he was attending full-time and working full-time as a police officer and maintaining a grade point average of approximately 3.0. We certainly think these things all speak to Officer Roth's character. With respect to his personal life and family life, it's important to note that Officer Roth is a native Georgian. He has grown up here and lived here all of his life, and the majority of his family resides here in the Atlanta area.
Okay, so that was the defense. We're going to move on to the prosecution. Now, for all of our trial watchers, remember the Tex McIver case? Remember that one? Clint Rucker, the prosecutor there? He's the prosecutor here. Here's where he says this is the real story of the case.
That the employment status and the history of the defendant should be taken into account. And so we know that Officer Roth was a 7-year police officer. We know that he was trained in drug recognition. We know that many of his colleagues are very fond of him. But the fact is that the mayor and the Atlanta Police Department terminated Officer Roth's employment within 24 hours after looking at the videotape that we have submitted to the court as part of our responsive brief. It has been described, his actions that is, as excessive, unnecessary, and actually characterized as murder. And that is because, Your Honor, the videotape is clear. This dispute that Mr. Thomas claims that we have about the facts of the case is really no dispute at all. And I know that we are not here to decide the merits of the case, but the reality is that the strength of the case is strong. It's so strong that it would provide a motivation for Officer Roth to flee this jurisdiction to avoid criminal prosecution. He certainly now has the means, which was not discussed in the defense presentation, because we know that he has received upwards of $250,000 in cash donations. We have not heard anything about the surrendering of any passport that he may possess or any other conditions that would give the court some confidence that Officer Roth would not be a risk to not appear in court. The reality is he does not have a job. He is not employed anywhere else. He has no income or any of the things that traditionally the court would look at that says, hey, this guy is a good risk for me if I gave him a bond, because he's got these things that connect him very closely to the community.
Okay, I'm back here with Terri Austin. I also have with me trial attorney Ann Bremner. Ann, it's great to have you back here. I'll start with the decision from the judge. Was that the right call to have him a $500,000 bond, which he was ultimately released on?
We look at likelihood of flight and dangerousness to the community, and there's a right to bail. And so I think that given those circumstances, his attorney did a good job. I also should say, Jesse, I've defended police officers for decades, the Seattle Police, Portland Police Bureau, Chicago, and I've been on call for police shootings at all hours for many, many years, responding to scenes. It's very difficult. I know it's not a popular thing to say right now, to be on the side of an officer, but these officers make split-second decisions, and I think there has to be some balance in looking at these types of cases.
Well, you raise an interesting argument because, Terri, even though the prosecutor said the video is pretty straightforward, the question is it? You heard this back and forth between both sides yesterday, and sort of, I would say, a preview of what a trial could look like. Is this a straightforward case? Will it be easy for a jury to come up with a verdict?
I don't think it's going to be easy for the jury. And, you know, I think the whole bail system has to be reanalyzed to determine when defendants should be let out and when they, you know, should stay in jail. The fact that they have money or they don't have money, the fact that they're going to flee or they're not going to flee, the nature of the crime itself. And here in this instance, while I agree, Anne, with what you're saying, I also think that the fact that we have Rayshard Brooks, who was literally, you know, shot while running away. Yes, he turned. And that's why I think it's going to be very difficult for the jury, because he did turn, he did use the taser, he did shoot it at Rolfe or the police. And so I do think it's going to be difficult. But again, it was deadly force. And was it necessary? Could they have done other things? Yes, they absolutely could have done a perimeter. They had his car, they had his address. They could have done so much more than kill this young man.
I tell you, at the very least, I think everybody could agree it's a difficult case from a human element, whether it's the officers or Brooks, because what we heard yesterday was Tamika Miller, who is Rayshard Brooks' widow. And she actually, when she was giving her statement, she had to be excused for one moment and then came back. Here's just a sample. You're going to hear this back and forth between her and the judge. Very emotional moment.
So, Your Honor, I'm asking that the bond does not be granted due to my health, my mental state. I have to still raise my children. I don't have a big support group. It's just me and my children. That's all I have. My best friend has been taken. My helpmate has been taken. And never in a million years I would imagine myself being called a widow.
Ms. Miller, I want to thank you. I don't know if you can hear me, but I want to thank you for speaking to us today. And I heard you. All right. Thank you, ma'am.
Thank you.
Like I said, it doesn't make it any easier. Well, from one high-profile police-involved death to another, we're going to focus on George Floyd right now because we have an update for you. J. Alexander Kung, who is one of the four officers, he is actually charged with aiding and abetting murder and manslaughter. This is all George Floyd, who died after that controversial police arrest that was caught on tape. Well, he has now said what his defenses will be, and he is claiming self-defense, reasonable use of force, as well as authorized use of force. And let me start with you. Interesting defenses here. What do you make of that, particularly self-defense?
Well, right. I mean, these are affirmative defenses. I understand in that jurisdiction they have to plead, you know, up front. But the fact is, police officers can use force to defend themselves, to defend others, to take someone into custody, to overcome resistance. They have a right, a privilege, and a duty to use force. So that's what he's saying. But I don't know if, and again, Mr. Brooks's death, of course, is very problematic. And I'm not saying that officer acted appropriately. I'm just saying that there's certain analyses that should go into these cases. And of course, George Floyd is one that's clearly a wrongful death, at least from my perspective. But the fact of the matter is he's saying that there was a struggle before the death, I think, and that he was one of a few, of many that were involved in the restraint. And so he's saying what he was doing was justified under the law. And I don't know if in that jurisdiction the state has to prove the absence of self-defense beyond a reasonable doubt. I know in my state they do. So that could be the strategy from his lawyers.
Well, I don't understand. Well, the defendant has the burden of proving the self-defense claim. But Terry, if I read the law correctly, there had to be some recognition that Floyd was about to commit a felony or be a danger. And again, he was apprehended for a counterfeit $20 bill. So what exactly is the law here on this? I mean, how is this going to work for him, if it'll work, particularly because these officers are to be judged at that moment in time? Not hindsight, not looking at it now, but at that moment in time.
Well, that's exactly right. And I think the only reason you see this being filed as a self-defense is because if they don't file it from a legal perspective, they won't be able to claim it later. I think that it's just pro forma, and frankly, there is no way that they could claim self-defense if, in fact, the video, and we see it right here, speaks for itself at that point in time. There is no self-defense. He's on the ground. He's handcuffed. 3 people are on his body holding him down for over, 8 minutes, obviously on the neck. He has a smile on his face. He's got his hands in his pocket. So that clearly is not going to prevail.
Yeah, and look, it's interesting because the judge has said that he's expecting a trial maybe March 2021, even suggested that he'd be open to televising that trial. Obviously, cameras are not allowed during these pretrial hearings, but maybe during the trial, and we'll get a better insight into what's actually going on. Look, when we come back, 2 other high-profile individuals we'll talk about, Robert Kraft and Harvey Weinstein. Stay tuned. We'll be back. And welcome back, everybody. Now it's time to turn to NFL owner Robert Kraft. You remember how he's facing these 2 misdemeanor counts of solicitation of prostitution for allegedly receiving sex acts at a Florida spa? Do you remember how a lower court judge threw out the surveillance footage of this sting operation, saying that the way police recorded this was unconstitutional? Well, there was a hearing in front of the Florida State 4th District Court of Appeal to determine if it was legal for the judge to suppress this key evidence. I say key evidence because the question is, without this footage, can the charges really stick? Let's listen to the Deputy Solicitor General during this hearing saying the recordings weren't that long. Take a look.
You look and compare this search and the length of this search to the lengths of searches that are routinely discussed in federal video and wiretapping cases, this is vastly shorter, 5 days. A great example would be the Torres decision out of the 7th, which is a case that my friends on the other side rely on heavily. That was a 150-day video surveillance operation, 150 days. And in Kraft and Zhang, it's 5 days, so a 30th of the Torres search. The same is true in Dorfman.
In the order in the Zhang case, the court made 2 decisions as far as minimization was concerned, as I read it. One was that the warrant itself did not specify how law enforcement was to minimize the intrusion on the privacy of those involved. And then the second, which is what you were addressing, was more the implementation of the warrant and how much time was spent. But the warrant itself in the Palm Beach County cases had nothing in there really about minimization other than citing a federal case.
And now let's hear Robert Kraft's attorney saying what the police did was wrong and illegal. Take a look.
This is where Officer Sharp testifies that contrary to what he submitted in the warrant application, right after he got authorization from the issuing judge, they put in an undercover officer into this spot. I didn't mean to interrupt, Your Honor, but I think it's important to underline that point.
There's several cases here, so getting all the facts right in each one is a little challenging.
And Judge Sickland, we stand by our submission that it was wholly gratuitous to resort to this very dangerous, problematic, invasive form of surveillance here. And there's no question of standing. It's a gating issue. I think it is absolutely clear under all the cases that have decided this question that the Fourth Amendment requires a showing of necessity before the state can put covert video surveillance into private settings, and that necessity showing is heightened, the demands are heightened, the more private and sensitive the setting. And here we're talking about private massage rooms where patrons would be undressing as a matter of course. So the state has an especially high bar it needs to clear in order to establish necessity. And my best authority for the proposition that they didn't come close to clearing it, Judge Sickland, is Mr. D'Souza. Because Mr. D'Souza tells you what is clear from the warrant application. That the state had been successful in stopping male patrons coming out of the spot, went 4 for 4 in obtaining their confessions that they had paid for sex acts while they were at the spot. That's in the warrant application. The state had also been successful in recovering physical evidence via trash pulls. That's in the warrant application. And it's also in the warrant application that they got credit card receipts and a spreadsheet as to the financial aspects of these transactions. So it's not just that traditional investigative techniques could work in this case, just as they've worked in prostitution cases since time immemorial. It was working. By all indication, traditional investigative techniques were perfectly fit for purpose. And that's why Mr. D'Souza can say, look, it was no surprise what was uncovered, according to law enforcement, when they started spying on the spa, because they knew what they were going to find. And indeed, they already had abundant evidence of it. So there's really no coherent necessity justification that can be found from the state. That's my respectful submission, Your Honors. And if I give the state every benefit of the doubt, what they were still looking to prove is not that there were sex acts that were being performed and being paid for inside the spa, it's that proceeds were being derived and that those proceeds were going to the register. Well, look what the warrant application and what the warrant tell you about where evidence of that would be found. It's at the front lobby of the business is where the exchange of money is believed to be occurring. You can find that in the record 3260, that's the warrant application, and 3264, that's the warrant itself.
Now, Ann, let's start, because the court didn't issue an opinion. You heard the back and forth when you were watching this. You heard the judge's questions. And I'm curious which way you think that this is going to fall, because Kraft's attorneys raised a great argument that clearly the lower court, lower judge believed that this warrant was obtained improperly, that the recording lasted way too long. It even captured legal conduct going on. Right. How do you think this appeals court is going to rule?
I'm seeing, I think right now, first of all, as a dream team, of course, and they did an excellent job below, and they're doing a great job right now. It also hinged, of course, is on the right to privacy. And remember, they used basically a subterfuge of a bomb threat to get into the building. So I think it's going to be, the decision is going to be upheld.
Oh, you do? Okay, well, let me ask you this, Terry. Isn't there a possibility we could see a situation? I think this is maybe what the prosecution said. Hey, why don't we just throw out all the footage you have of legal patrons doing legal things, and you just keep in the footage of Robert Kraft and anybody else getting these sex acts? You meet in the middle.
Well, Jesse, the reason they can't do that is because it doesn't have a deterrent effect. And if you have evidence and you've gotten it the wrong way, all of it should be thrown out. And I definitely agree with Ann. I think that the decision is going to be upheld. I'm 99.9% certain of that. And the reason is, in these various cases, the warrant didn't include all the right information. The police actually said they didn't actually read the cases. And in fact, they didn't minimize what they were supposed to go in and see. So there are a variety of reasons why this was not written correctly and executed correctly. And if they don't, in fact, throw it all out, it's not going to deter police from just going in, saying anything and doing anything. There is a Fourth Amendment right to a search and seizure here that is fair. And in this case, it was not.
Well, here's what we do know, that if this footage is not eventually let in, it's very likely the charges would be dropped. And if the case does proceed, you got a $6 billion guy who's definitely going to take this to trial, and it's misdemeanor. So I think he's going to be okay. But it is interesting from a legal point of view. Now, talking about somebody who's not in great shape, Harvey Weinstein, because a big update to talk to you about. A settlement has been reached that to resolve two lawsuits involving Harvey Weinstein. One is from the Attorney General's office in New York, and one is a class action on behalf of several women who have accused Weinstein of sexual misconduct and abuse. This settlement is in the tune of almost $19 million. The idea is that if this is approved by a court, a victim impact fund will be set up where claimants can actually obtain anywhere between, I believe, $7,500 to almost $750,000 per claim. Now, I want to ask you, Ann, is this good? Because some of the lawyers for the accusers, or several accusers, who have objected to this and said this is not a win at all. They've actually called it a complete sellout. Is this a win? I mean, do you think that this is a good thing, this $19 million settlement?
I don't know. I mean, if you put a pin on the map just anywhere in the United States, you could find another one of his victims, I swear. I mean, I've got one here in Seattle. I mean, you've got people that don't have access to his funds right now. You don't know exactly what the insurance situation is. You don't know what his assets are. And I know that people have opted out and said, we're not going to be a part of that. So is it a good thing? Well, not for everybody. We don't know, does he have endless assets? He's heading now to criminal trial in Los Angeles, of course. So And he's got,
Right.
talk about a dream team, he's got expensive lawyers that have to go from coast to coast to defend him. So,
and look, their main argument is it's not great because he doesn't have to admit wrongdoing. Then again, in a practical point of view, Harvey Weinstein's in jail the next 23 years. And you have to think maybe at the end of the day, this is a good thing to spare these women from going on the stand and testifying about what happened to them. But at the very least, here's what I do know. Terri, Ann, you've both been fantastic this hour breaking down these cases with you, so thank you so much. Everybody out there, have a safe July 4th weekend, and we will be back on Monday. We'll see you then.